Welcome to the Midweek Edition of LegalAF, the top legal podcast providing analysis of the most consequential developments at the intersection of law and politics with your regular team of midweek anchors, Michael Popok and Karen Friedman Agnifilo. We have a special crossover edition, Karen, of LegalAF, because we're joined for our first segment by Anthony Davis, journalist, podcast host, and broadcaster. And he's the host of 5 Minute News and the Weekend Show on the Midas Media Network. He's unvarnished, he's unbiased, and he's here with us today to talk about our first topic. Our first topic, speaking of first topics, the Biden administration and its State Department has made a decision to seek immunity for Crown Prince Mohammed bin Salman, who's also known as MBS, in a suit brought by the widow of journalist and US citizen Jamal Khashoggi of the Washington Post, who was brutally ambushed, tortured, killed, and dismembered in 2018 in Istanbul at the Saudi consulate. According to the U.S. intelligence community, that was done by order of MBS. So why did the Biden administration weigh in and argue for immunity? And what does it mean internationally to our global standing as a defender of human rights? Anthony Davis will join us for this discussion. Then Karen and I will talk about the revelation just yesterday of a secret trial that was conducted last December but didn't get disclosed until yesterday, in which a New York State Supreme Court judge, Judge Merchan, found the Trump Organization in criminal contempt even before the Trump Organization trial and conviction on 17 felony counts, including tax evasion, even began. They were already in criminal contempt before that even began. Was its disclosure this week a signal from the New York trial judge to Chief Judge Beryl Howell in the District of Columbia and the Department of Justice about Trump's unclean hands when it comes to documents? I'll give you my view, and we'll hear from Karen on that. Next, we discuss the New York Attorney General Leticia James filing her motion to dismiss Trump's and the Trump revocable trust suit in Florida, now in a Florida federal court, in front of probably the least favorite judge that Donald Trump could face, Judge Middlebrooks, Don Middlebrooks, in which Donald Trump is trying to get a federal court in Florida to dismiss and prevent the continued prosecution of the civil fraud case in New York by Leticia James's office. This is now in front of the same judge who just last month dismissed Trump's suit against Clinton, Hillary Clinton, and a whole load of Democrats, and sanctioned Donald Trump and his lawyers as well. But terrible draw for Trump. We'll talk about what it means. And we'll end tonight's podcast with the possibility that the biggest hammer in the Department of Justice's arsenal against the Jan 6 defendants and future ones like Donald Trump, the obstruction of an official proceeding felony count with its 20-year sentence, may be on life support based on an appeal and an oral argument that's pending before the D.C. Court of Appeals in Washington. A dozen federal prosecutors and FBI agents watch the oral argument from the gallery and want to know what the result is going to be because it changes the approach of the Department of Justice in their interactions with current Jan 6 defendants. It changes convictions that have already happened based on obstruction counts and would change irrevocably future indictments of people using what has been the biggest hammer in the Department of Justice's bag. That's a lot to talk about at midweek, but we're going to do it as we always do. Karen, how are you? It's so great to see you in what I've now discovered is a real actual library.
It is.
I thought it was a backdrop that you used, and then you swiveled your camera around, which we'll now do for those that watch us on YouTube, and showed me how wrong I was. This is actually a real office behind me, but for some reason I thought the angle showed that was some sort of amazing backdrop. But no, I'm wrong. So, but I'm glad you're here. How was your week? How was your week of being a lawyer, a defense lawyer, and all that great stuff?
It's been good. It's been a really good week, getting ready for the holidays, trying to figure out what gifts to give and all those various things. But it's been good. How about you?
Oh, it's great, and I'm doing the same thing as you are. I'm trying to check off my shopping list with Hanukkah and Christmas on top of each other this year, and maybe some people during today's show will get some inspiration by some of our sponsors, and maybe
I
use some of our.
actually, one of our sponsors that we're going to get to later is
Yeah,
one of the gifts that I've given and will be
so
giving
great,
several people because it's a great sponsor, but we'll
so
save
great,
that.
and I know
It's
you're going to
not
do that
Bombas.
ad. You're going to do that ad read, and I love that new sponsor. We'll talk about them when we get to it. But let's get to something really less lighthearted and much more serious, which is the United States human rights policies and a recent decision by the Biden administration and its State Department to intervene to argue that the Crown Prince of Saudi Arabia is not responsible or can't be sued in a federal courthouse by the widow of Jamal Khashoggi for his dismembering death and all of that. For that, I'd like to bring in Anthony Davis, our colleague on the Midas Media Network, broadcaster extraordinaire, host of the 5 Minute News and the Weekend Show. Just brings an amazing, even though he lives in America now, an international perspective based on his longtime work with the BBC and others. So, Anthony, we're pleased to have you back on the show. And I think this is a perfect segment for us to talk about. Let me frame it over 2 minutes, and then I want to get both Karen and yours view about it. So here's the undisputed facts. We have a crown prince of Saudi Arabia who really runs that regime in Mohammed bin Salman, known as MBS. And the U.S. intelligence community has no doubt and delivered that report to Joe Biden really upon his move into the White House, that MBS had given the green light, the go order, to send an execution team of 15 people, including 9 of them that were on his personal security detail, known as the Rapid Response Team. He first devised an elaborate trick and a plot to get Jamal Khashoggi, who had written unfavorable press and articles about Saudi Arabia when he was at the Washington Post, and this just gets more heartbreaking the more I tell the story. Jamal was about to get married, eventually married, who is now the plaintiff in the case against Saudi Arabia, a woman, and needed certain paperwork from Saudi Arabia, which he had left behind living as an expatriate in the United States years ago. When MBS, according to the intelligence community, learned that he needed this paper, the plan was hatched to trick him into getting back onto Saudi soil, in this case, the consulate sitting in Istanbul. And when he got there, of course, ambush him, not give him the paper he was looking for, instead torture, kill, and dismember him, literally, while he was there, and his fiancee, then wife, never got to see him ever again. And so that happened in 2018. And since then, there's been this litigation that was started by his fiancee, or now wife, actually, in federal court in District of Columbia. And there was a battle, or has been a battle, doctrinally, from a immunity standpoint, as to whether the crown prince was head of state or something akin to it. Because if he wasn't head of state or something to the equivalency, then he would not have immunity. But if he was head of state, he would have immunity. And that goes back to a long line of State Department policies and positions that the United States has taken, almost in an unbroken chain of precedent, about no matter how heinous the crimes, if the person that did it is a head of state, he's not going to be able to be sued in the United States for that. And so for a long time, and the timing of this is important, for a long time, it was suspect whether the crown prince, being just the crown prince, not head of state, would be able to successfully argue that he had immunity. And given the strategic geopolitical importance, apparently, of Saudi Arabia to America through every administration, not only because of oil and its OPEC role, but also because of its geopolitical situations and its location in the military world, and as a buffer against other regimes, especially as it relates, for instance, with Israel. Let's be honest. The U.S. government has made a devil's bargain a long time ago with Saudi Arabia, and Biden appears to have been in no position to not honor that bargain. But the State Department made a decision to wait as long as they could to weigh in until the Saudi family, led by MBS's father, made a decision at the very last minute, literally the day before the federal judge ordered that the State Department file its position on immunity. The day before, King Salman, the father of MBS, stripped off one of his own titles, that of Prime Minister, and gave it to his son, thus cloaking him in immunity, because the State Department already made clear that Prime Minister is a head of state and would enjoy immunity. It's fishy. It happened apparently with the United States's, I don't know about endorsement, but at least with their sanctioning of it. And we need to talk about it because we talk about hard things on LegalAF. Let's bring in first Anthony. Anthony, what did you think about all this, and what's your perspective about the Biden administration and the timing of waiting for the Crown Prince to be given a better title?
I think it's less about the Biden administration and it's more about the United States of America, because this probably would have happened with whichever administration would be in. And as you know, Trump did a whole bunch of arms deals with Saudi, including one for around $350 billion just halfway through his presidency. I mean, it's not just fishy, this decision to kind of take the king's role, because of course the king automatically becomes the prime minister in Saudi Arabia. That's kind of how it works. So to strip the king of his own title and to give it to his son in this way and suddenly make him prime minister, of course the only reason they did it was because of this, so that he wouldn't be accountable. Even though the king had already taken responsibility for they said we take responsibility for this crime, but then they don't expect for anything else to come from that. And so this is really more about the relationship between the United States and Saudi Arabia, or Saudi Arabia and the rest of the world. I don't think it's specific to Biden. The issue with Biden is that he made a promise that he wouldn't sell any more arms to Saudi Arabia. He called them a pariah. He had all this rhetoric leading up to the election. He did stick with it. And now, obviously, as time passes and there's deals to be done and money to be made, it's yet again the United States putting the dollar above human rights and above a moral compass.
Yeah, I think you put it perfect there. Let's bring in the former prosecutor, Karen Friedman Agnifilo, for her views of, Biden's ultimately making that hard decision, but making a decision to allow this to happen. I don't think anybody should think this was like Sleepy Joe asleep at the wheel and he got outfoxed by Saudi Arabia. I don't know how involved we were in the decision making, but the State Department was waiting an awful long time until the very last moment to give the Saudis time to give the title that was necessary to MBS. What do you think, Karen, from a prosecutor standpoint as well?
Yeah, so there's all kinds of immunities, right, that we afford people in the United States and elsewhere. One of them from the criminal side is, for example, diplomatic immunity. And that has to do with diplomats, foreign diplomats who come to this country and sometimes commit crimes. They cannot be prosecuted here without the consent of their government. And most of the time they just whisk them away and, take them back and say, we'll deal with it in our country. And the reason we engage in these types of agreements with countries is because when we have our diplomats that go on foreign soil, we want them to be afforded the same courtesy, frankly, because as we all know, there are laws all over the world that are very different than ours. And if you find yourself, like Brittany Griner, who was in Russia, who was arrested for being gay and having residue in her vape of marijuana, that those things aren't illegal here. And that is apparently illegal there. And so she was arrested pretextually, obviously, but she was arrested. If she had been a diplomat, for example, she would have had immunity and would not have been prosecuted. And what happens is she gets arrested, and then we have to do things like deal with the real devil, with Victor Bout to get her out. And it's very difficult. And so that's one of the reasons we do this with, this is sovereign immunity. One of the reasons we recognize this applies in the civil context here. This was a civil suit. This was not criminal, but it's the same kind of thing. It's, how you will have jurisdiction over a governmental entity, whether it's your own or whether it's another country, but it's very much because we also want that same recognition in the rest of the world. So that's why we do things like this, and we engage in these types of very difficult decision making, so that our people can be protected as well in places that might not have the kind of due process or court systems or laws that we have. And so, it was a very difficult decision that I think had to be made, but had to be made. There's absolutely no other way around it. Sovereign immunity stems from our days, when we were affiliated with England and the King of England. And, you just it comes from a tradition of the government, can't do any wrong. And so therefore cannot be sued without its consent. And so that is the rule, that is the law. But there is, because obviously in our country, we recognized that governments can do wrong. So we passed the Federal Tort Claims Act that spells out when you can sue the government. The law is very clear. And I think Biden didn't have a choice, and I think had to do it this way. But frankly, everyone knows it was a farce that MBS was made prime minister just to avoid this. But I think more than anything, they wanted to avoid a diplomatic disaster if he was allowed to be sued in this country, and frankly, the just disaster that would come with discovery and all, this was just a heinous crime. And the more you look at it, the less it's palatable to have this diplomatic relationship with Saudi Arabia. So I think for everyone's sake, they just want this to not be front and center so that we can go on with life.
Yeah, I thought that's a good overview. The politics aligns people and administrations in strange ways. When the Saudi government was the subject of new legislation after 9/11 in the form of the form of JASTA, the Justice Against Sponsors of Terrorism Act, Hillary Clinton at the time was a big proponent of it while she was still in the Senate. But when it reached Obama's desk, and this would have allowed people like the 9/11 families at that moment to sue directly the Saudi government for their involvement in 9/11, Obama vetoed it, and it took a full Congress to override the veto. And so, people, if you just take one thing out of context, you could say, Obama was against the 9/11 families. But there are these more complicated geopolitical issues, especially around Saudi Arabia, that come into play. And unfortunately, I think what's left for people like Khashoggi's wife is going to have to be an act of Congress that somehow overrides and allows for this particular immunity to be removed and to allow her to have a continued suit. Anthony, what do you think about cases like the 9/11 families and their ability to go against the Saudi family, and whether there would be a political will to have some Congress allow such a case to go forward, as an exception to the general immunity standards?
I think the US would just love all of this to go away, wouldn't it? Because, ultimately, this is not something that the prosecutors want to deal with. It's not something that politicians want to deal with. It's the kind of unfortunate nature of geopolitics where you need to do business with countries that are, murderers. I mean, the detail of this particular murder with Jamal Khashoggi if you read into it, the way his body was dissolved in acid and all this stuff. I mean, it's horrific. I can't help but think, back to your question, I can't help but think that if he was like a white American citizen, then the reaction might have been slightly different. And then obviously with 9/11, part of the problem there was that, initially there was this huge political diversion as to who was the perpetrator of this crime. And, it was pointed to Saddam Hussein. It was pointed to Afghanistan eventually. And then, of course, they find the perpetrator in Pakistan. But it had, 17 of the 19 bombers were Saudi nationals. And so, again, it's another situation for America to have to deal with. It's like, well, I guess just business, it's just business all the time. It just comes down to business. And this is what drives me mad. There is nothing to stop Biden from saying, okay, no more arms deals. So you have to ask the question, who is putting pressure on Biden to continue selling arms to Saudi Arabia and supporting the war in Yemen? Who is putting pressure on the US attorneys not to give the 9/11 victims the justice that they deserve? I mean, there is clearly, in England we refer to it as the establishment. If you've seen the Netflix documentary with Harry and Meghan, you'll learn about the forces, the dark forces that are behind a lot of these decisions. As an outsider, I'm kind of asking you guys as American citizens, who are those kind of unspoken dark forces, not the deep state, I'm not going into conspiracy territory, but clearly there are decisions made at a very high level that are recommended to the President of the United States and to to federal prosecutors. Who's making these decisions? Who's advising these decisions to kind of just skirt Saudi Arabia at every opportunity?
Yeah, I think you hit the nail on the head earlier when you said that this is not just Biden. This is just a long, unbroken chain of State Department and diplomacy decisions and military decisions where we're going to just bet on Saudi Arabia. I mean, there's a reason why it's not just those photos of, George W. Bush literally holding hands with King Salman. Biden does it too. Trump did it. I mean, they all do it because
they fist bumped. I seem to remember.
Well, yeah, right, because COVID was happening. But if you were able to lift Saudi Arabia out of its geopolitical location and put it somewhere else that was less vital to American interest, or you sucked all the oil out from under Saudi Arabia, or you didn't have it as part of the Middle East, I assure you that the decision making would be different. If this was a sandy patch in Africa that had no role whatsoever and no spillover effect on policy making, they would not be kowtowing to and looking the other way on Saudi Arabia. Saudi Arabia is so worried about its reputation that it literally formed a multi-billion-dollar sport league to compete with the PGA in live golf, and is overpaying primarily American golfers, hundreds of millions of dollars to whitewash their bloody hands. And the American
But Saudi Arabia has got so much money. I mean, this is part of the problem, isn't it? They have an unlimited supply of funds, and the US does not in the same way. Certainly where I'm from in the UK, arms is the second biggest export from the UK, and Saudi is one of the biggest customers to the UK. BAE Systems is one of the biggest arms companies there. And so we have the same conversation in England all the time about this. And it just boils down to the fact, certainly in England, we don't have much GDP. I mean, we don't really make anything anymore. We just have financial services and arms deals.
And actors.
Broadcasters and actors. Exactly. So I can see why the UK, as a small country with very few assets, relies on Saudi Arabia in terms of sales. But I don't understand it with the United States, where it has massive GDP. It has a huge opportunity to kind of, build in America, hire in America, make in America, and yet it's still relying on these these deals to sell tanks and missile systems. I just don't get it.
I don't think it's that, but I don't think it's necessarily GDP driven. If they weren't sitting on top of oil wells and in control in part of OPEC and OPEC Plus, and they weren't so important to to our democratic ideals in the Middle East.
That's what I think it is.
And our strategic relationship with Israel, which is important for anybody that doesn't think it's important. Just go to Israel and you'll understand almost instantly the importance of Israel to our American foreign policy and democracy having any role at all in the fabric of the Middle East. I think it's that the extra I almost said shekel, the extra dollar that the America makes from selling arms they could do without that. They can make it up somewhere else. But I don't think you can turn your back if that is your foreign policy, which it has been for 60 or 70 years. Then you have to hold your nose, which is what it appears every administration does.
And World War III might have something to do with it as well, don't you think?
And averting World War III.
Right. There's nice. Iran, who is right there, and Iran is, of course, the enemy of Saudi. Yeah. And Iran, as we know, we're kind of always on the brink of war with Iran, or some people are kind of goading it to happen. I know Trump was probably looking to start a war in Iran. But that is the other problem, isn't it? It's the geography of that area.
That's
and
right.
Who's on the side of the Sunnis and who's on the side of the Shiites, and so you end up in a situation and America has to pick a side.
Yeah. As unsavory as picking that side is, Anthony, every time I have you on the show with Karen, I'm always saying to myself, we got to bring it back like once a month at least. We made that promise last time, and then we didn't do it. And we would talk to you at length on every segment today if we could. But I think Karen would like to come on your show. I'll come back on your show. 5 Minute News, the weekend show with Anthony Davis. Always a pleasure to have you on with us, Anthony, and happy holidays to you and your family.
Same to you. Thank you very much, guys.
Thank you. And we can't segue out of that segment, but I'm going to try, Karen. Did you know that your temperature at night can have one of the greatest impacts on your sleep quality? Did you know that, Karen? If you wake up too hot, or I didn't either, although I get hot or cold during the night, and I always wonder why and what I can do about it. I highly recommend that you check out Miracle Brand's bed sheets. It's inspired by silver-infused fabrics made by NASA. Miracle Brand makes temperature regulating bedding so you can sleep at the perfect temperature all night long. Boy, this would solve a lot of problems for me. I've always got that one leg sneaking out because I get too hot during the night. Do you know that traditional bed sheets can also harbor more bacteria than a toilet seat? Yuck.
Disgusting.
It can lead to, I know that. Let's read that again. Traditional bed sheets can harbor more bacteria than a toilet seat. It can lead to acne and allergies and stuffy noses. It's just, there's no other word for it, Karen. It's just gross. Miracle Brand, however, offers a whole line of self-cleaning, eco-friendly bedding such as sheets, pillowcases, and comforters that prevent 99% of bacteria and require 3 times less laundry. It uses that silver-infused fabric that I mentioned that was developed for NASA. They're thermoregulating and designed to keep you at the perfect temperature all night, whatever that perfect temperature is for you, so you can get a better sleep every night. And they're self-cleaning. These sheets are infused with natural silver that prevent 99.9% of bacterial growth, leaving them to stay cleaner and fresh 3 times longer than other sheets. No more gross odors. Couldn't get that out. Gross odors. There we go. Miracle sheets are luxuriously comfortable without the high price tag of other luxury brands. They are, here we go, the perfect gift for your spouse, friends, or family. We're right at the holiday time when you're trying to make a list of what you can buy people. Who doesn't want to sleep and who doesn't want better sleep and luxurious feeling bed sheets? And since these come with 3 free towels, you get 2 gifts in one just in time for the holidays. It's better for your skin. Stop sleeping in bacteria, Karen. How many times do I have to tell you that? Clean sheets mean less bacteria to clog your pores and fewer breakouts and other skin problems. Go to trymiracle.com/legalaf. That's TRYMIRACLE.com/ what else? LegalAF to try it today or gift it to someone special this holiday season. And we got a special deal for our listeners and followers and watchers. Save over 40% and be sure to use our promo code LEGALAF, LEGALAF at checkout to save even more and get those 3 free towels. And Miracle is so confident in their product, it's backed with a 30-day money-back guarantee. So if you aren't 100% satisfied, you will get a full refund. Upgrade your sleep with Miracle brand. Go to trymiracle.com/LegalAF and use the code LegalAF to claim your 3-piece towel set for free and save over 40% off. Again, that's trymiracle.com/LegalAF to treat yourself, a friend, or a loved one this holiday season. Thank you, Miracle Brand, for sponsoring this episode. We're glad to have you on board as one of our many sponsors. Karen, it's a miracle that we're even getting through these segments as rapidly as we are. And here's my favorite one of my favorite ones for tonight. And this has to do with your old office, the Manhattan DA. And we just learned yesterday that the Trump Organization was the subject of a mini trial in December of last year, secret. No one knew about it until it was revealed by the court yesterday. We'll talk about why that happened, in which the judge, and in a 28-page order, found the Trump Organization in criminal contempt beyond a reasonable doubt for their willful flouting of orders and subpoenas that had been issued to the Trump Organization. The judge had had enough after reciting all of the facts of all of the shenanigans there with the Trump Organization. The judge threw the book at them and found them in criminal contempt. The only reason we didn't find out about it in advance is because the judge didn't want a future jury and the jury to learn that the Trump Organization had already been found in criminal contempt, had been convicted of something before the start of their tax fraud case, because, and I think rightly so, they didn't want the jury to be biased against the Trump Organization. The timing of it is interesting, but first I want to get, Karen, your view. You got Salman Shinerock, a former colleague of yours, who apparently handled the trial successfully. Let's talk about when a prosecutor asks for criminal contempt and when a judge issues it, what is it and why does a court use it? And what does it mean that the Trump Organization got found in criminal contempt before their main trial even started?
Yeah, so it's not widely used, criminal contempt, frankly. I only remember it being done one or two other times recently. And it's something that is done when somebody willfully disregards court orders. And so what was happening at the time is Salman Shinerock, who was an assistant district attorney in Manhattan investigating the Trump Organization, what they were doing during the investigation is issuing multiple grand jury subpoenas. And if everybody recalls, the grand jury is a secret proceeding. And so grand jury subpoenas are also secret, and anything that comes is secret. And so what was happening was the paperwork they were subpoena ducis tecum, which is a Latin phrase for documents, subpoenas for documents. And so as opposed to a subpoena for a person to show up. So they were producing these documents, and they were producing, frankly, thousands of documents that the prosecutors were going through. And however, they could tell that there were certain documents that were not being provided. And what ADA Shinerock would do is would ask again and give them more time, and ask them again and give them more time. And then after a while, when he wasn't getting a response, he brings them to court. And he went in front of Judge Merchan, who then ordered the Trump Organization to produce those missing documents. And once again, they didn't produce them. So he ordered them again, and he ordered them again. I mean, there were so many opportunities they were given, the Trump Organization, to produce these documents. I believe there was 4 grand jury subpoenas and 3 court orders. And they specified what the documents were that they wanted. And the Trump Organization just, once again, they squirrel away documents. They don't give them over. They don't comply with subpoenas. And so you have nothing else to do but charge them with contempt. And it's a it's a crime, criminal contempt, and you have to prove it beyond a reasonable doubt. You have to show that what you did was willful and knowing. It was, you willfully disobeyed the grand jury subpoenas, not that it was an accident, so that's what you have to prove beyond a reasonable doubt. And because the grand jury was secret at the time of this trial, and the investigation continued, and they didn't want the investigation to be spoiled. The trial happened and it was sealed, which is very rare for a criminal case. Criminal cases and criminal trials are public by virtue of the United States Constitution. And so, the fact that there was a trial going on here, and nobody knew about it and it wasn't secret, it was because of the grand jury secrecy laws. But what happened was the grand jury eventually was disbanded, or was no longer there. And at that point, they could have unsealed the finding of this trial. But as you pointed out, Judge Merchan, because of the publicity surrounding this case, there's no way that prospective jurors wouldn't have heard about that, and that could taint them and be considered overly prejudicial, because they would see how they are such obstructionists and don't and basically have a criminal conviction, if you will. So that's what it means. And now but now that the trial is over and before sentencing, Judge Merchan, I think that was the reason he did it now, because I could bet you anything he's going to take this into consideration when he sentences them, and use this as a reason to sentence him to the max, which is not very much, but at least he can do that now. I think the only fine for this particular criminal contempt is $4,000. So it's not like, there's no teeth to any of these laws. So why wouldn't Trump continue, and the Trump organization and the Trump family, why wouldn't they continue doing what they do, which is they have complete contempt for any law, for any order, for any judge. They do what they want, and then they fight it. They bring these frivolous suits, they make frivolous arguments, and they just don't do any. For them, it's like, so who cares that I'm held in criminal contempt? All I have to do is pay $4,000. What they end up doing is they end up delaying things, and they end up just using the court system for their own benefit. And I just think at a certain point, it's outrageous to see how they just do not follow the law. And the fact that we have somebody who's running for president and who was president, who just flagrantly does not follow the law, is just, I can't wrap my head around it. I don't understand. There's just no respect for the rule of law. And this is just yet another example, just the willful disobeying of court orders to turn over documents in a criminal investigation. And that's what they did.
Yeah. Here's my view. The fine is ridiculously low. I don't even know why Merchan only issued $1,000 for each violation. Your old office asked for $60,000 a day, and he certainly was empowered to do more. But just a couple of points of clarification, not to your analysis, but just for our listeners and followers. The reason the Trump organization was being subpoenaed and it wasn't being done through some other way, is because technically the entity that was convicted, the two entities that were convicted of the 17 counts of tax fraud and business record fraud, was not the Trump organization. It was the Trump Corporation and the Trump Payroll Inc. And so the Trump organization, which was their parent company, but through which these two companies, they did all their business. That's why they were being subpoenaed, as opposed to having documents produced some other way in the process. I think this was yes, it was important to get this out in the public record, as Judge Merchan said when he finally, after a year, unsealed a partially redacted version of the 28-page order. But I think this is also, as you said, this is Trump just thumbing his nose time and time again. But if Merchan hadn't released it now, the Department of Justice would have been in the dark just as much as the public was. It's not like the Department of Justice has a secret, line into all court systems and all sealed documents and knows everything that's going on in an omniscient fashion all over the country. It was news to the Department of Justice that the Trump organization actually got to the level of so pissing off and flouting the orders of a sitting judge that a criminal contempt trial was held. This will help, and conviction was obtained. This will help the Department of Justice and ultimately Chief Judge Beryl Howell, who just last week took a lot of flack for denying the federal Department of Justice's motion for contempt on very similar, eerily similar issues. This is the pattern that we see with Donald Trump. It's he doesn't appoint on purpose a records custodian who becomes responsible under oath for certifying the search for documents that was done, that it is complete under penalty of perjury. None of the lawyers want to now step into that and vouch for their client because they know their client's not trustworthy and their own law license can be jeopardized. See 4 other lawyers who have or are about to lose their law licenses, including Rudy Giuliani, just up the street in Washington, D.C. So the lawyers don't want to do it. Nobody wants to volunteer to be a records custodian for Donald Trump. There's no more dangerous spot to be in than to be his records custodian. Donald Trump doesn't want to do it because of all the criminal implications of signing something. So he doesn't. So he didn't do it in New York. The records custodian that he did appoint was basically useless and had misled the court, a fraud on the court in his own testimony in that court. Your old office, Solomon Shinerock, asked him, have you been a records custodian before? Oh, yes, I've responded to dozens or hundreds of subpoenas that have come into the Trump organization over the years. We have it down to a science. We have a way to do this. Have you ever been found, sir? Has it ever been found that your conduct in being a records custodian fell short of the requirements and you were punished or penalized? No, never. Well, the reality is he had been, and the Trump organization had also been in trouble before in responding to other subpoenas in other cases. So you have the same thing going on in Judge Beryl Howell's courtroom on the grand jury subpoenas. Nobody wants to be a records custodian. Nobody wants to vouch for Donald Trump and an adequate search having been done of all of the places under his dominion and control looking for documents. And so now the Department of Justice can wave around Judge Merchan's ruling and say, Judge Howell, you should know, if you haven't seen it already, that the Trump organization, led by Donald Trump, was convicted of contempt. This is now on the books for every war. Criminal contempt related to their document production conduct. Isn't that the same thing that's going here? And that'll ring a bell for this judge and future judges, whether it's the Georgia judges related to Fani Willis's prosecution or anybody else. It is now stamped indelibly like a scarlet letter on the Trump organization that they have been found in criminal contempt related to documents in a very important case that led to 2 major subsidiaries being convicted of 17 counts of fraud. So it sounds like you were as surprised as everybody else was that this got released a year after it happened, right?
Yeah, I had no idea. I mean, I was completely surprised by it, but I agree with you that this is very much to other judges who are also being the referee over whether or not documents have been produced, and to show the willfulness of the fact that they just thumb their nose in the face of the rule of law. So I agree with you. I think this is as much for other judges. Look, frankly, I think it's relevant for the Mar-a-Lago document case as well. It's very much his MO and his people's MO of what they do. So I agree with that.
And that's Beryl Howell. Yeah, listen, judges don't sleep in hyperbaric chambers or under a rock. They read the papers. They see the media. I know Merchan knew that Beryl Howell just denied a motion for contempt, and he probably rang a bell in his head and said, I'm sitting on a criminally convicted Trump organization on some of these very, very issues. Trial is over. Maybe it's time for the public's knowledge and justice, which is what the judge said as his rationale for releasing it now. And I agree with you. It's both sentencing and a clarion call to other judges, and now an indelible stamp on the Trump organization that they can't be trusted. And it's now been so proven in a court of law on document issues. There comes a time in the show when sometimes, Karen, I am just inclined to treat you like royalty. I mean, I try to treat you like royalty as a co-anchor anyway, like Lady Karen, something like that. Wouldn't that be great if you could be Lady Karen?
That would be absolutely amazing. I would love, it's my dream actually
to have that title, right?
To be royalty. So, we have a really interesting product from one of our sponsors. It's called Highland Titles. Scotland is unusual in that it has legally defined in the Land Registration Act of 1979 a souvenir plot of land. These plots of land are so small that their value is solely commemorative or sentimental. They're a novelty, and you can buy them as a gift because these plots cannot be registered with Scottish Land Registry. There's no conveying of the land. There's no solicitors or land taxes involved. And even though these plots cannot be registered in a conventional way, customers can obtain a personal right of ownership, and it's a valid form of ownership which can be passed on to future generations. So what can you do with your 1 square foot of Scottish land?
What can you do with your what? I was just asking myself, Karen, what can
Highland
you do
Titles,
with your what?
It allows you to style yourself as a lord or lady or laird of your estate. And each luxury gift pack comes with a personalized certificate which displays your new style and identifies your unique plot number. You can also look on Google Maps and see your plot of land. So it's not too late for Christmas because you can actually download your personalized certificate after checking out and use the discount code LegalAF to receive 25% off at www.highlandtitles.com. I actually, after seeing I've seen this before, and I've thought it was really interesting. And so I actually, one of my very close friends, today is his 11th birthday. And right before we started taping, I went on there and I did this for him, and I'm going to present him. He's Laird Alexander, and I'm going to present this to him.
This is so great.
He's going to have that. I think this is a fantastic idea. I absolutely love it.
I with Meghan and Harry so quickly giving up their titles, I think it's great that you can, through this Highland Titles company sponsor, you can get a title, you can buy a title and get a 3.3 times 3 size plot of land. Great for the holidays, all the holidays, Hanukkah, Christmas, or whatever you celebrate, or just to give a fun novelty gift to a friend.
Am I going to have to start calling you Lord Popok?
You mean again? No. No, although I do like Lord Pope. I do like the sound of it, and I think this is a very fun sponsor for us to have, and really welcome them to the show. Let's turn to the other reason that people love our show is our analysis of legal and political issues. Let's talk about the New York Attorney General, Leticia James, and doing battle, not in New York, not where she should be doing battle, where that has jurisdiction over her and her case against Donald Trump and all of the little Trumpettes, all the little children of Donald Trump, in the civil fraud case brought under her very broad powers, unique powers as the Attorney General of New York, to go after people and individuals who are continuing to commit fraud in the state. And our statutes here, specifically 63-12, give her extraordinarily broad and muscular powers against a company that's been accused of fraud, even in the civil context. Well, Donald Trump doesn't like the way that case is going, and having already lost in a New York State jury trial, criminal with a much higher burden of proof on his main company, his only company, on 17 counts of tax fraud. He's now staring down the barrel of a civil fraud case that actually probably has more ability to disrupt his finances and his life and the operation of his business in New York than even the criminal trial does. Because the criminal trial with a jury, yes, he's convicted, and that will now stay on the Trump Organization's record and will make it difficult for them to get conventional lending, to get insurance, to get licenses. But over on the civil side, this might sound counterintuitive, but we've talked about it in past podcasts. On the civil side, the judge and the New York Attorney General have tremendous power if a jury finds that they have committed civil fraud, Trump and his children, to take away their company, to give it the death penalty, make sure it doesn't do business in New York any longer. And Leticia James is seeking at least a $250 million worth of disgorgement back to the state of New York for what she believes is ill-gotten gains or profits. Well, Trump doesn't like all of that. And where is his favorite jurisdiction? His backyard in Florida. And he files cases all over the state. He tries to do it in the northern part of the state, hoping to get a great judge for him like Eileen Cannon, and he was successful. He just filed a case against the Nobel Peace Prize Committee because they gave out a peace prize based, in his view, on the Russia interference reporting. So he sued them from a county nobody's ever heard of in the middle of the state called Okeechobee County, probably because he's got another buddy there or a Trumper is sitting on the bench there. And then he ran down to his other favorite place, the courthouse in West Palm Beach, first in the state court, because he's already scared of Judge Donald Middlebrooks. Judge Donald Middlebrooks, which is the senior judge in the West Palm Beach division of the Southern District of Florida. And as people know, I've been in front of him over the years in various cases and trials. He's a no-nonsense judge. He's apolitical, but you better come prepared in his courtroom with the law and the facts on your side or you're going to be tossed out. The case that he originally filed against Hillary Clinton and all of the Democrats and Democratic National Committee and Debbie Wasserman Schultz and all these other people with just a vendetta lawsuit, a performative lawsuit, as Judge Middlebrooks called it, just political in nature, having nothing to do with the law or the facts. That was tossed a month and a half ago by Don Middlebrooks, dismissed with prejudice and a finding of sanctionable conduct by Donald Trump and his lawyers, and he's in the process of awarding up to $1 million in fees to the other side who had to defend this BS case. That's the Don Middlebrooks, Judge Middlebrooks we're talking about. Donald Trump decided that he was going to try to drag Leticia James, the New York Attorney General's office, all the way down to Florida and a Florida courthouse and try to argue there that she doesn't have jurisdiction over his major asset, which is his trust, which he formed, where apparently all of his financial assets are sitting, and trying to get a Florida judge to interfere with the New York judge and the New York powers and put a stop to the civil fraud case in a New York courthouse. Even the first listener, the person who's only listened to the show for the first time today, is probably saying, how does a Florida court have jurisdiction over a New York court's proceedings? The answer to that is it doesn't. But Donald Trump, trying to avoid Don Middlebrooks for the second time, filed it in state court at the courthouse across the street from the federal court, hoping to God that he would get a more favorable audience. But I guess what he didn't bank on was that Leticia James would immediately, based on the filing of a one-page document, which gets the case removed and brought from the state system over to the federal system, and then randomly assigned to Don Middlebrooks. Karen, you got Don Middlebrooks sitting over there. You got Leticia James having filed her recent paper. What do you make of all this? And what do you think Don Middlebrooks is going to do with his second bite at the apple of Donald Trump and his attempts to involve Florida courts in New York civil fraud cases?
Does that count as a related case because it's Trump?
I don't think so. I don't think it's the party that makes it related. It would be if it relates. I think the way the related party part goes on the civil cover sheet in this matter would be you'd have to reveal the existence not of a prior case involving Donald Trump, but it'd have to be involved in some way overlapping with the prior case, which this one does not.
Yeah, so interesting. So I think it's clear he's going to throw this out and say, we don't have jurisdiction over this. Go to your own federal court in New York, or go deal with the judge that you have in New York. I mean, this is so clear that he's just trying to use what he views as more favorable judges in Florida to evade New York law and get better rulings because he doesn't like the ones that he's gotten in New York so far. And, the bottom line is, she called him, Tish James, the Attorney General, in her filing, asked the judge to reject this lawsuit that he's filing, calling him disgruntled, and he's seeking emergency protection for his trust. But because he accuses her of invading his privacy. His whole theme is that if she gets the things that she wants, she'll immediately widely distribute it, and that's an invasion of my privacy. But I don't know where he even gets that from. The various people who are investigating him and who have all his information and documents have not leaked anything, actually. So I really don't understand where he gets that from. But I think the judge is going to throw it out. I mean, it just makes no sense. And it's so obvious what he's doing. However, what I'm hoping is that the judge sanctions him, not just throws this out, because at a certain point, you have to say enough's enough. You can't use the justice system the way he is using it through his fake lawyers who have no ethics whatsoever to just manipulate people and try to manipulate the system. At a certain point, I think judges are going to have to really start sanctioning him. What do you think?
Yeah, I think Don Middlebrooks is going to be hard pressed to find that there was any merit to the filing of this case. This is a whole nother crop of lawyers we haven't heard about before that are sitting in Tampa, but that's not the brains of the operation. There's been a lot of reporting that Boris Epshteyn, a lawyer who's on the radar for the Department of Justice and a target of their investigations, he's like the new consigliere for Donald Trump and he kind of practices all the dark arts related to him, and he caters to Trump's darkest instincts. And he's the one against, apparently, the recommendation and strongly held belief by other lawyers like Eric Corcoran and Jim Trusty and the other ones that are handling matters in New York, not named Alina Habba, that this was a terrible strategy to try to file a case down in Florida, which they did the night before the major hearing in front of Judge Engeron in the civil fraud case. It was terrible. It looked bad. It allowed Leticia James to point fingers at it and talk about, of course, we need an injunction and a financial monitor in place, Your Honor. Look what they just did. They're trying to use their trust in Florida to deny this court somehow to have jurisdiction over all of his assets. I think it only reinforced and strengthened Leticia James's hand in that hearing. It was a stupid timed filing. If Boris Epshteyn is responsible, it was a terrible strategy. And it was also a terrible strategy to think they were going to avoid federal court by just filing it in state court. Who among practicing lawyers that know anything about procedure wouldn't think that Leticia James would immediately file a notice of removal to take the case out of the state court system and into the federal court system, because there is jurisdiction by the federal court, because Leticia James is a resident and a citizen of New York and Donald Trump is something of Florida, and you've got a dispute at hand, and therefore diversity jurisdiction of the federal court obtains. And the little so they got great press the first day because it got filed in state court. It immediately got sucked over, and then as fate would have it, Trump gets the worst pick possible in Don Middlebrooks. So to answer your question, I totally agree with you. I think Judge Middlebrooks not only dismisses the case, he ultimately sanctions the lawyers again and Donald Trump with, here you go again, citing back to his own opinion and ruling in the prior case. That's where the related part comes in. Don Middlebrooks doesn't have to forget or have amnesia about what happened in his courtroom in another case involving Donald Trump. And this can start. Everyone's like, why isn't he found to be a vexatious litigant? Well, you're starting to build a record of being a vexatious litigant who files meritless cases, especially when it's in front of the same judge. Now it's going to be 0 for 2. So I think we're going to see a very strongly worded ultimate ruling. Middlebrooks, to sum it up, is not going to exercise jurisdiction over the civil fraud case in New York. He is not, because he can't issue any orders in any way impairing the ability of the New York judge, his colleague in New York, to not hear the case, the jury not to hear the case, or Leticia James, New York Attorney General's office, from trying the case or prosecuting the civil fraud case. Nothing. There's no power over it whatsoever. And this made up thing that you talked about, Karen, that to give some sort of good faith, although I don't think it's good faith, argument that Florida has some sort of jurisdiction over the case because of the existence of the trust in Florida, because they'll reveal things in the public and embarrass me. That's not good enough. A, as you said, it's never happened. That office doesn't leak at all, and B, it's not proper grounds for jurisdiction. So we will follow that case closely.
Can I ask,
Lady Karen? Yes.
Can I ask you two questions?
Yes, sure.
Number one, can you define for everybody what a vexatious litigant is? And number two, going back to the Khashoggi thing that we were discussing, let's say sovereign immunity wasn't a thing, how would the plaintiffs there have jurisdiction since the event happened? Because I know some of the defendants were dismissed who weren't sovereigns for lack of jurisdiction. How did they have jurisdiction over MBS if there was not a sovereign immunity question?
Yeah.
If you know.
Yeah, I think it has to do with the definition. I think if you look at the Foreign Immunity Act, which defines all even though it leads in the title with immunity, it defines jurisdiction, and there are exceptions to it that were made after JASTA, after the 9/11 families moved for an exception for them, in which, in certain circumstances, even if the bad act, the murderous act, happened on foreign soil, that's okay if it was targeting an American citizen. So the hook is that Khashoggi was an American citizen who had been tortured and killed on foreign soil. So it doesn't have to happen in America the way the expansive immunity statute works, as long as, now, if it wasn't a U.S. citizen, I think, if let's say a Canadian living in America had this happen to them, I'm not sure they'd be able to use U.S. law to find that jurisdictional hook. On the vexatious litigant thing, that's just the doctrine and a set of statutes in most states and in the federal court as well, that says that if a party, a plaintiff, continues to file, and there's really there's no like numeric definition, like you get the first 5 filings are fine, but the 6th one is found to be vexatious. If each of your filings up to an amount that the trial court listening to the issue thinks is too many, after warning, and they've already been, the Trump organization or Trump's already been warned by Middlebrooks once, continues to file meritless cases. Now, usually it's on a same or similar set of facts, or same or similar claims. It's just like the pro se jailhouse lawyer who keeps filing over and over again things. It's usually people that aren't represented by counsel who just continue to file at the clerk's office petitions and motions and all of that. And this is a way for the court, using its inherent authority, to say, you know what? Generally, the courthouse door, the clerk's office, is open to everyone in our justice system, but you've so abused your right to do that we're going to shut the clerk's window to your future filings. But you got to really get to the level of lawsuits. And the reason why I don't think vexatious litigant has been happened, or the doctrine's been applied yet by Trump, even though he had 70 cases here, and so it has to be generally in the same courthouse on a similar issue time and time again. You might be able to expand it to be the same litigant in the same courthouse on different issues where each of them have been found to be meritless, subject to Rule 11 sanctions under the federal rules for meritless filings. But I think that's where that's going to play out. I don't think we're yet at vexatious litigant doctrine application against Trump, but we're getting close. And I'm sure Middlebrooks is getting pretty hot under the collar, under his black robe, about Donald Trump as plaintiff.
Thank you.
Make sense? All I know is Donald Trump and all of his false filings and misleading filings and all of that over the last 2 years has not only turned my hair gray, but I'm sure I'm losing a strand or two, losing sleep at night, and that's why I'm glad we have one of our newest sponsors, Nutrafol, on board to help. You don't have to choose between better hair growth and your health anymore, because there's a holistic solution for men that promotes both healthier hair and whole body wellness. And you can get ahead of thinning hair with Nutrafol's whole body approach to hair growth. No drugs, no compromises. I know friends that use this particular product over others because of this holistic approach to hair growth. And not just sort of a topical thing, but a holistic whole body approach. Nutrafol is the #1 dermatologist recommended hair growth supplement. Let's repeat that. #1 by dermatologists for hair growth supplements, and it's clinically shown to improve your hair growth thickness and visible scalp coverage. Nutrafol's hair growth nutraceuticals go beyond genetics to multi-target the root causes of thinning, including stress, as we talked about, hormones, nutrition, metabolism, aging, and lifestyle through whole body health. Physician formulated using natural medical-grade ingredients, Nutrafol's drug-free patented technology provides consistent, reliable results without compromising your sexual health. In a clinical study, men showed progressive improvement in hair growth and thickness after 3 and 6 months. Nutrafol is also trusted and recommended by more than 3,000 top doctors. You can grow thicker, healthier hair and support our show, Legal AF, by going to Nutrafol.com/men and entering the promo code LegalAF. Let me do that again. It's a little bit different. Nutrafol, Nutrafol.com/men, MEN, and then you enter the promo code LegalAF to save $15 off your first month subscription. This is the best offer anywhere, and it's only available to U.S. customers for a limited time. Plus, free shipping on every order. Get $15 off at Nutrafol.com/men, Nutrafol.com/men, promo code LegalAF. How do you like that, Karen?
I think it's great.
It's only for men, but we're going to look for a women's product as well.
No, they have a women's product. I think I looked on there because I actually am somebody who has to deal with thinning hair as I'm aging. And so I'm always looking for ways to improve that. So I went online and they actually have women's products as well. So I'm very interested and very curious. By the way, this might be the first time we've had 3 sponsors.
It may be.
Midweek.
It may be. Much to the delight of all of our listeners and followers. Let's turn to our last segment, which is a interesting issue, but one that could have devastating impact on the Department of Justice and its continued prosecution of all those responsible for Jan 6 at the lowest and highest level. It's been no secret that the secret weapon in the arsenal of the Department of Justice has been the threat of and the actual indictment and conviction related to obstruction of an official proceeding as a criminal count. It's been on the books as a crime since 2002. It was passed in the aftermath, that law in the aftermath of the Enron scandal. We have so many scandals today, including FTX and all of that, and Bernie Madoff and the collapse of all these companies. But back in the day, in the late 1990s and early 2000s, Enron went down, and that resulted in a whole bunch of legislation being passed by Congress, one of them being obstruction of official proceeding. It was passed because of a Supreme Court case at the time that found that a then existing obstruction count did not cover the actions of Enron not properly cooperating with its regulators and other investigators in turning over documents. But that's not what the actual statute says. All it says is that someone or something that corruptly interferes with an official proceeding is guilty of a crime punishable up to 20 years. Now, the Department of Justice has added that, where appropriate, to 300 of the 900 or so people that have been indicted and are being prosecuted. 300 of them have in their indictment a count of obstruction. They've used it in the negotiation process to try to get plea deals. I'm sure been very successful with that. They've even put it on a trial successfully in the last 4 or 5 trials, including just 2 weeks ago when Kelly Meggs and Stuart Rhodes of the Oath Keepers were convicted of what else? Obstruction of an official proceeding by the jury. So it's important to the Department of Justice. Why is it on potential life support? Because of a case coming up from Judge Nichols, Carl Nichols, who we talked about in the past, a Trump appointee who was the presiding judge in the Steve Bannon contempt case and sentencing. Judge Nichols stepped kind of off sides and was the only federal judge so far to have ruled in the District of Columbia that the obstruction charge was improper because by its terms, it doesn't apply to the facts of January 6th. Specifically, Judge Nichols back in March ruled in a case involving Grant Miller, so U.S. versus Miller, that the government would have to dismiss that portion of the indictment on obstruction of an official proceeding, because unless there was evidence, and this is a Nichols view, that Miller interfered with the actual documents of the ballots of the electoral counting, then he wasn't interfering with an official proceeding by just attacking the Capitol to try to stop the count. Seems very esoteric and very wrong in the analysis. And frankly, no other judge in the federal courthouse in the District of Columbia, where all these cases are being prosecuted, believes that. And all of them have allowed that count to stand, except for Judge Nichols. So it went up to the Court of Appeals that sits over the courthouses, the federal courthouses in D.C., the D.C. Circuit Court of Appeals, with a 3-judge panel. And based on that 3-judge panel, and the results of an oral argument this week, I think it's on life support. Let's first talk about the 3-judge panel, and then I'll turn it over to Karen. The 3 judges are Judge Florence Pan, who is a Biden appointee. You can put her already on the side of finding that Nichols made a mistake and made reversible error, and she's in favor, based on her questioning, of having the obstruction count stand and not be removed from all these indictments. On the other extreme, you have a Trump appointee who used to serve in the Trump White House as a deputy general counsel, deputy White House counsel, Greg Katsas, and we've talked about him before in recent cases. He's on the other extreme. He thinks that obstruction count only applies in event of criminal corporate fraud. It has to be corporate fraud for Greg Katsas to apply that count. And then right in the middle, you've got the youngest judge on the panel, 39-year-old Justin Walker, who not only was a Kavanaugh law clerk, but a Kavanaugh apologist, having given 119 interviews, literally 119 interviews, when the nomination of Kavanaugh hung in the balance over sexual assault and abuse charges against him before he was confirmed. Judge Walker never tried a case. He's only been a clerk, a Supreme Court clerk twice, worked in the Department of Justice, was never a judge before he became an appellate judge, and never tried a case. But this hangs in the balance with him being the swing vote about whether the Department of Justice is going to be able to have this in their arsenal or not. And all the prosecutors are very concerned. There was reporting that they were sitting in the gallery watching the oral argument along with FBI agents just to see how this was going to shake out. Talk about what do you think is going to happen, and what does it mean from a prosecutor's standpoint for current cases and cases that have already led to conviction on those counts, Karen?
Yeah, so I'm going to put this in perspective. Obstruction on the state level of when you have protest cases, which in Manhattan we had all the time. We would have these gigantic protests for whatever issue, and you have a constitutional right to protest peacefully. And even if you are blocking the Brooklyn Bridge or walking in the street without a permit, nobody would arrest people because they were executing their constitutional right peacefully. So even though they're technically breaking the law. And so the only time people would get arrested for doing it is when they take it a step further. So when, for example, there was a whole Occupy Wall Street thing going on here where lots of people were basically living in a park and in one of our parks, and they refused to leave. And so for a long time, the police left them there and allowed them to be there because you can exercise your constitutional rights. But at a certain point, they can order you to leave. And what some protesters will do is they'll do things like chain themselves to a tree or to a fence or together and then refuse to move. And at that point is when they can get arrested and charged with a crime, because at that point they're obstructing, something. And it's in New York, they call it obstruction of governmental administration. That's an A misdemeanor. So it's a very low level crime. What was happening when there was Black Lives Matter protests in New York, there were thousands of people who were getting arrested because they were doing things like looting. They were, breaking into stores and stealing things. And a lot of people got arrested for that. And the prosecutors, you have to make a decision of what is it that you're prosecuting them for, because there's sort of gradations. You're the person who went inside, is that a burglary or is that a trespass? Is it a felony or is it a misdemeanor? If you stole something, if you masterminded something. I think the problem here is this obstruction case in the federal system. They don't have kind of gradations. They don't have okay, you protested and went inside. You protested, went inside, and engaged in violence. You protested, went inside, but you were one of the masterminds. There isn't a lot of gradation. They really just have this charge that carries up to 20 years, and that's a pretty significant, hefty crime. And the Department of Justice used this for over 300 people. And I think that is what is going to get them potentially in trouble, because I think the judges are going to say, these Trump appointee judges in particular are going to say, you know what, you went a bridge too far. If you'd saved it for the people who were like the masterminds, like the Stuart Rhodes, who, orchestrated this, or Donald Trump, frankly, who is the person who planned it and executed it and cited people and did it, that's clearly, in my opinion, obstructing an official proceeding. But doing it for these other people who may not have had the intent necessarily to stop the electoral vote, but just wanted to go in and wreak havoc, or to, be violent, or to, do all the things they were doing. It's a little tricky, I think, to apply this particular statute to so many people. And I think as a result, they stretched the law. And I have a feeling the court is going to say, you know what, I don't think it applies here. Now, the one saving grace, I think, is the statute requires not enough to just obstruct an official proceeding. You have to corruptly obstruct an official proceeding. And the corruptly means you have to have a criminal state of mind. So I think that is the only lifeline about this. But the legal language of 18 United States Code 1512 sub C sub 2 is whoever corruptly or otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. So that's the particular legal language. But I think it's a little thin to apply that to all 300 people. And as a result, I think that it's going to be interesting what happens if the 3-judge panel decides that it does not apply. Now, how can they get a full panel of the DC Circuit, Popok? How does that work, where you go from 3 to the full panel, and will it be appealed to the Supreme Court? I mean, I think we do have a few more stages to go before we can say what's going to happen to all the people who've been convicted. But I think
it's going to, I think it's going to be 2-1 in favor of Nichols' interpretation and stripping the Department of Justice from their ability to use this count. Before I answer how it gets from 3 to full en banc, let me ask you a quick prosecutor question. People have been convicted of this count already, like Stuart Rhodes and others. What happens to them? Do they get a whole new trial, or does that conviction just get vacated for that particular count?
No, it gets vacated. It becomes in a legal. I mean, they'll have to move to have these these vacated or dismissed, or whatever the procedure is going to be, depending on what stage the case is in. It could go normally. What would happen if something like this happens is the defense attorney would make a motion and would say, my client was unlawfully convicted of something that the courts have says don't apply to this particular person. The prosecution can either agree or disagree, and the prosecution could potentially say, okay, I agree, and we'll join in this. Or they could say, you know what, his conduct actually does, this person did alter a document, so it still stands. And then you'd have to have some kind of a hearing to determine that. Now, I think it's going to also depend on if someone pled guilty versus if they had a trial. If someone pled guilty, they'll probably be able to get their plea back. Or if there's another charge, they'll let them plead to the other charge. I mean, it really procedurally will just depend on what state people are in, given the stage of their case.
I think that the Department of Justice will have no choice but to ask for en banc consideration, because the numbers are in their favor. There's more appointees by Democratic presidents to the D.C. circuit than there are Republican. That's the one area that Trump wasn't able to overly impact, even though he got the Supreme Court and a lot of other appellate places. The D.C. circuit was not one of them, and I think they'd have a better shot at it. They make a request, and there's a vote, and there's a vote before the vote to decide whether there's going to be en banc. And if there's going to be en banc, which is all of the judges of the D.C. circuit hear it again, including the ones that just heard it. And then if there's a majority decision from it, doesn't have to be unanimous. If there's a majority decision from it, they can overturn the 3-judge panel. And then, of course, you're off to the U.S. Supreme Court, and Lord knows what they're going to do. The swing vote is really Wilson. Walker, I'm sorry, who was a Kavanaugh guy, a Kavanaugh clerk. And that's why I think, Walker took such offense during the oral argument at Nick Smith, the advocate for the Jan 6 defendants, because Nick Smith said, well, where are you going to draw the line? What about all the people that went down to Florida in 2000 and all the lawyers that descended on Florida during Bush versus Gore to try to find votes and protest the vote counting? And, why wouldn't they be obstructionists under the statute? And that was even too far for Walker, and Walker knew that Kavanaugh had been one of the lawyers that had descended on Florida in 2000 on behalf of the Republican Party. By the way, I was down there for that at that very moment, and I had a role in on the Gore side in making sure that vote counting was done properly in all of those places. That was the moment of the hanging Chad and the butterfly ballot, and
I remember that.
Pat Buchanan who was a virulent anti-Semite, getting lots of votes in the Jewish communities of Boca, which made absolutely no sense and ultimately led to a 5-4 decision that elected George Bush president by the U.S. Supreme Court. But even Walker was like, don't use that as your comparison. What happened on Jan 6th, even in the view of a Trump-appointed appellate judge, was heinous, unprecedented, violent, and all of that, and shouldn't be compared to lawful protest, First Amendment expression about, my guy won over your guy, and let's make sure the vote counting is done properly. So that's called not reading the room right as an advocate, by leading off with that and not knowing that the person in the black robe, his mentor Kavanaugh, was one of the lawyers that descended, quote unquote, down in Florida, what was then called the Brooks Brother riot. All these Republicans running around in khakis and light blue button-down shirts like they just walked out of Brooks Brothers, protesting in the streets for the first time in their lives about the vote counting. So we have that. We're going to have to watch it closely. It has tremendous ramifications and impact on the prosecutors in this case, of course, the defense attorneys, future prosecutions, as Karen laid out, past prosecutions and convictions. It'll really, it's a Pandora's box. We're hoping that the appellate court doesn't open, but if they do, as Karen outlined, full panel, the 11th Circuit will probably hear it. Whatever happens there, U.S. Supreme Court. And now the Department of Justice has to, continue to assess whether they want to have that as a charge in their indictment and double down on it, or they want to, like you said, remove it and only use it in certain circumstances. But I don't think the certain circumstances are whether somebody touched a ballot or not. First of all, there's no evidence that anybody got into the chambers to actually touch an electoral ballot that was being counted at the time it was being counted. You know, the session of Congress was halted. That's part of the obstruction, and the goal of the object of the obstruction was to stop the counting. And as they got all of the lawmakers to safety. So if that's your standard for the application of that, you have to touch the piece of paper or the document or interfere with it in some way, then I think that's a very narrow, I'm not saying that is your interpretation, but that would be a very narrow reading of that particular obstruction statute. And, you know, I know that judges like Katz's on the bench said, well, if you look at the legislative history, it's really only for corporate fraud, and it talks about corporate fraud, and he even said, half jokingly, Jan 6 is a lot of things, but it's not corporate fraud. And so he's out. That's going to be a no vote to reverse Judge Nichols. I think Judge Pan, as I said, Florence Pan, the first Asian American to ever be on the D.C. Circuit Court of Appeals, who took Ketanji Brown Jackson's seat, she's going to be a vote for reversing Judge Nichols and keeping obstruction on the books for the use in this circumstance. And it's going to come down, unbelievably so, to Judge Walker. So, and that ruling's going to come out soon. I don't think they're going to sit on that a long time, given that there are trials that are still going to trial in the next few months that have this count embedded within them, and all the other people that are waiting around to see. And the prosecutors, you know, did it surprise you that the reporting is that there were line prosecutors sitting in the room watching this oral argument?
No, not at all. Of course they were.
Yeah.
And this is very significant to them. I mean, this is one of the tools they've been using in their toolbox on how to deal with this. So they're very interested in what happens here.
Agreed. Well, unfortunately, we've reached the end of another midweek edition of Legal AF with my illustrious royalty co-anchor, Karen Friedman Agnifilo. We're bringing you a specially cultivated show of those most important consequences at the midweek at the intersection of law and politics today. Special shout out to a guest of ours, Anthony Davis, fellow podcaster and broadcaster and journalist and host of the 5-Minute News and the weekend show also on the Meidas Media Network. Shout out to all of our sponsors, Miracle Brand, Nutrafol, and Highland Titles. And having them on the show was great fun for you and I to do those ad reads. And Karen, I got a weekend show with Ben Meisalis on Saturday, but then right back at it with you during the week leading into the holidays next Wednesday.
Can't wait. See you next week.
We'll see everybody next Wednesday. Thanks.